Thank you everyone for your patience. For the record, today is Wednesday, October 26, 2022. This hearing is being conducted both in person at the Volunteer Conference Room inside the Cordell Hull Building at 425 Representative John Lewis Way North in Nashville, Tennessee, and telephonically using Microsoft Teams. It is also currently being recorded. If you do have any technical difficulties or for some reason get disconnected and are not able to rejoin this hearing, please contact Kawana Barbie with the State Board of Equalization. You might want to pause here. I'll read her phone number so you can call her. Her direct line is 615-747-5386. If you forget that number or lose that number, feel free to email us or call our general line at our help desk, and we'll make sure we get you reconnected. We are present today before the Tennessee Assessment Appeals Commission. These commission members have been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related items. My name is Robin Pope. I currently serve as Executive Secretary to the State Board of Equalization. I'm designated to sit with the Assessment Appeals Commission as a hearing officer today pursuant to the Uniform Administrative Procedures Act, Chapter 4, Title 5, Section 301, subsection B. As the hearing officer, I will preside at this hearing, rule on questions of the admissibility of evidence, advise the commission members as to the law of the case, and otherwise ensure the proceedings are carried out in accordance with law. I will now make some introductions before explaining the procedure for today. During deliberations, Emily Bennett here on my right will serve as counsel to the commission. She will assist the commission with questions during deliberations and offer guidance regarding the legal sufficiency of their conclusions. All right, I am getting some feedback on our online line. Just FYI, just be aware if you're not actively speaking or it's not your turn to speak, just you might want to stay on mute until we call your name for your appeal. I will now ask our commission members on our panel to introduce themselves for the record. I would ask if any of our online participants are not able to hear our commission members, give us a shout and just make sure you can hear us. So in no particular order, I'll start with my man immediately to my left, Mr. Rhett Turner.
Rhett Turner, real estate appraiser, Mount Juliet, Tennessee.
We'll proceed with Mr. Don Osborne.
Don Osborne, located in South Middle Tennessee.
And to our final commission member is Mr. Van Bowles.
Van Bowles from Brighton, Tennessee. I'm a real estate appraiser.
I will now ask our commission members to identify a presiding member. This presiding member will oversee the commission during deliberations and otherwise sign off on the final written order. So it is relatively flexible. Our chair of the commission is not currently here today, so we're just a presiding member to sort of help organize deliberations. You can do it by simple voice vote or volunteer.
One of you two gentlemen would be fine to do it with me. You want to do it, Van?
Well, why don't you do it, Brett? What was the question?
Which is our presiding member for deliberations, and you'll sign off on the final written order.
I guess I am voluntold, Robin, and I will accept it.
Thank you, Mr. Turner. All right, Mr. Turner, you will be our presiding member today, and I may do the liberty of reminding you that when we get to deliberations.
Yes, you guide me through it, please, sir.
All of the appeals to be heard today are to be conducted based upon the previous record available before the administrative law judge during the prior hearing. Pursuant to Tennessee Code Annotated 67-5-1506, quote, the Assessment Appeals Commission may affirm the decision of the hearing examiner or remand the case for further proceedings. The Assessment Appeals Commission may reverse the decision if the rights of the petitioner have been prejudiced because the administrative findings, inferences, conclusions, or decisions are either one, in violation of constitutional or statutory provisions. Generally speaking, did the judge follow the law or apply the law correctly? Subsection 2, made upon unlawful procedure. Did the judge not follow proper procedure, or is there some abuse of procedure in the record? Number 3, was the decision arbitrary or capricious, or characterized by abuse of discretion, or clearly unwarranted exercise of discretion? That one's a little more self-explanatory. Generally, was the decision arbitrary? 4, was the decision unsupported by evidence that is both substantial and material in light of the entire record? And B, in determining the substantiality of the evidence, you as the commission can take into account whatever fairly in the record detracts from its weight, but you as the commission members may not substitute your judgment for that of the hearing examiner or the administrative law judge as to the weight of the evidence on questions of fact. So generally speaking, from legalese is basically, was there a basis for the record? Was there a basis in the record for the judge's decision? You may not replace your judgment for that of the administrative law judge on questions of fact, but you're not required to ignore inconsistencies of evidence in the record that may suggest two answers. This means no new or additional facts, testimony, documents, or other evidence may be presented to the commission unless it is related to an irregularity in procedure that is not shown in the record. We will address those specific appeals as we get to them, but as far as I'm aware, we don't have any of those issues for you today. So what that means for our parties is that you're not being under oath, you're not going to swear in because there is no testimony here today. It is limited to oral argument. So what arguments do you want the commission to consider about why your decision was correct or incorrect? A copy of the record has previously been presented to both all our parties for their specific appeals, as well as to our commission members, along with any written arguments submitted by the parties in each case before the commission today. I have with me a physical copy of the administrative record for each appeal to be heard. I also have a physical copy of the initial decision and order for all of our commission members for all of our appeals today. We will proceed one case at a time, immediately following the other, taking breaks only as necessary. First, I will call roll of the cases we have docketed today. If you or your representative are present, please unmute yourself and let us know you are here. Unless there's a pressing concern, we will hear today's appeals in the following order. We will also make introductions for you at the beginning of your appeal hearing. So just we're testing microphones and making sure that everyone is present. So in no real particular order, our appeals I have for today are in regard to Brent Miller. I see Mr. Miller is in the room, as well as Davidson County is here. Our second appeal will be St. George Coptic Church. And I want to go ahead and test microphones if we may. May the representative for St. George Coptic Church just unmute yourself and make sure we can hear you in this room.
Father Serabion Gabriel from St. George Coptic Church.
All right, thank you. We can hear you. And then also we'll have Davidson County for on that appeal as well, but I believe it is one of our online participants. Whoever's representing Davidson County for St. George Coptic Church, just unmute yourself and make sure we can hear you in this room.
This is Lexi Ward with Metro Legal.
Thank you, Ms. Ward. We can hear you as well. Our final appeal today would be in regards to TK of Clarksville. I believe we have Mr. Jay Catnany on the line for that appeal. Mr. Catnany, I believe we heard you earlier, but would you mind giving us a shout again?
Yes, I'm here.
All right, we can hear you. And then I believe we also have Montgomery County in the room here as well. Again, we will make formal introductions at the beginning of each appeal. These proceedings are informal, and board members are allowed to ask questions at any time during the presentation of arguments. Once we've heard all of the arguments, I will briefly describe the charge to the commission members before handing it over to our presiding member, that's Mr. Turner, to enter deliberations. At the time we enter deliberations, no more communication between the commission members and the parties will occur. If you would like to have any more questions, you'll have to reopen the record and hear additional questions from there. Prior to hearing each appeal, I will read a copy of the initial decision and order under review and recite the administrative record that we have of the documents in each appeal. All right. Like I said, these proceedings are informal. Generally speaking, we will start with the appellant in this case, most typically the taxpayer, and then follow it up with any response from the county assessor's office. We'll then allow the taxpayer to respond to any arguments made by the county before I hand it over to the commission for deliberations. Unless there are any real immediate issues, we'll go ahead and just dive in. For our first appeal being in regard to Mr. Brent Miller. Like I said, I will read briefly the initial decision and orders to make sure we are all on the same page as to what is being reviewed by the commission. So I have this appeal entitled in regards to Brent Miller, property ID 119-140-18200 for tax year 2019. This is a Davidson County appeal, appeal number 128341. The initial decision and order reads, statement of the case. The Davidson County Board of Equalization, quote, local board, unquote, has valued the subject property for tax purposes as follows. A land value of $43,000, an improvement value of $335,200, with a total value of $378,200 and an assessment value of $94,550. The taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, on October 21st, 2020. The undersigned administrative judge, that being Judge Jerome Cochran, conducted a hearing on this matter on March 3rd, 2020 in Nashville, Davidson County, Tennessee. The appellant, Brent Miller, represented himself at the hearing, hereinafter the taxpayer. The Davidson County Assessor of Property was represented by Staff Appraiser Pam Williams-Ishii, hereinafter the Assessor's Office. Summary of the evidence, the testimony of the parties and the following exhibits. Exhibit 1, the taxpayer's drawing of the square footage of the subject property. Exhibit 2, the taxpayer's appraised values of nearby properties. Exhibit 3, taxpayer's drawing of the outside measurements of the subject property. Exhibit 4, the taxpayer's appraised values of property on the same street of the subject property. Exhibit 5, the aerial view of the subject property. Exhibit 6, the taxpayer's chart of the value of nearby properties based on price per square footage. And Exhibit 7, the assessor's office's valuation analysis. Findings of fact and conclusions of law. The subject property in this appeal consists of a single-family residence on 0.21 acres located at 2912 Tuggle Avenue in Nashville, Tennessee. The taxpayer contended that the subject property should be valued at $264,492. The assessor's office contended local board value of $378,200 for the subject property should be modified. The basis of valuation set out in Tennessee Code Annotated Section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11 subsection 1. At the hearing, the taxpayer testified that the assessor's office's measurements of the subject property are not accurate. The taxpayer further testified that other nearby homes had a value range of $150,000 to $190,000, which is well below the assessed value of the subject property, with the next highest value on the street being $264,492. The assessor's office testified that the subject property has been renovated with a new addition added and that the entire neighborhood has been improved. The assessor's office further testified that their comparable sales with adjustments in market analysis were an accurate reflection of the subject property's value. The assessor's office analysis showed that the subject property had a value of 324, I believe there's a cutoff there, and they are asking that the local board's valuation be modified. The taxpayer's use of appraised prices of nearby properties is not a reliable indicator of property values, as the values he relies on fail to make adjustments in values when compared to the subject property. Factors such as age, time of sale, building materials, size, and etc. were not taken into account in the comparable sales listed in his evidence. So these comparable values are not a reliable indicator of what the home values are compared to the subject property. The Assessment Appeals Commission has said that for comparable sales to be relevant, they must be properly adjusted. In E.V. Kissel Jr., a Shelby County appeal from tax years 1991 and 1992, the commission, meeting, this body today has previously said, the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. Final decision order at 2. And then I have a footnote. The footnote says the decision is referring to comparable sales. However, it is still applicable to comparable values in that the comparable properties need to be adjusted to make it a true comparison of the subject property. Based on a review of the evidence, the comparable sales analysis provided by the assessor's office with adjustments is compelling and appears to be a more accurate reflection of the value of the subject property. The assessor's office's properly adjusted comparable sales were more reliable than the comparable sales presented by the taxpayer. These sales established a range in value for the subject property of $367,500 to $389,500. This led the assessor's office to recommend a value of $378,000 for the property. However, they asked that the amount be modified based on the square footage measurements provided by the taxpayer. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The assessor's office comparable sales analysis supports the reduction of the value placed on the subject property by the local board. Order. It is therefore ordered that the following values be adopted for tax year 2019. A land value of $43,000, an improvement value of $277,400, a total value of $320,400, and an assessment of $80,100. Then the rest of page 4 cites the appeal remedies available to the parties. And page 5 quotes that the result of this appeal only becomes final 75 days after entry of the order. If no party has appealed, we're at an appeal this appeal today. That was entered on March 25th, 2020, and signed by Judge Jerome Cochran. So that is the initial.
Mr. Pope, I hate to interrupt, but what you and what we have are two different things.
Oh, thank you. That's the point.
There was an amended initial decision in order that is part of the record, and I believe you may have been reading from the original one that you said had an error in it.
Thank you. You were correct.
I don't think there's much difference in them, but I do believe that that the amended one is slightly different.
All right, that leads me to what maybe I should have started with, was the administrative record. I will pull up that amended order. Yes, thank you. All right, so Ms. Bennett has pointed out to me that on page, I believe, 4 of the amended initial decision in order, at the top of that page, this led the assessor's office to recommend a value of $378,000 for the property. However, they equalized the value to $320,000. He then notes the footnote on footnote 4. This corrects an error in the testimony regarding the basis of the assessor's office's recommended value. I guess I will ask if were there any other differences in this amended order I should read?
I don't believe so.
With that said, I will go through the notice of the administrative record. This is a document that my office put together and compiled. It's dated June 23rd, 2022. It cites the same case number, property ID, appeal number, and tax year. The notice is that the above reference matter is pending before the Assessment Appeals Commission under Tennessee Code Annotated, section 675-1506. The commission's review of this matter is limited to the existing administrative record. A copy of the administrative record as of the date of this notice will be shared with you electronically. An index of all the items currently comprising the administrative record is attached. If you believe any documents or other items are missing from the administrative record, you must send a brief explanation and a copy of the missing items to the Executive Secretary, that being me, of the State Board of Equalization, and copy the opposing party as soon as possible. A hearing in this matter has not been set. When a hearing is set, the parties will receive a notice specifying the date and time. We then have page 2 of that document, noting a copy of the record will be shared with the parties via Microsoft OneDrive using the following email addresses. To request additional access to the administrative record, please email Kawana Barbie at kawana.barbie@cot.tn.tov. If you contend any items are missing from either the below list or the Microsoft OneDrive, you must contact the Executive Secretary and copy the opposing party as soon as possible. I have the index of the administrative record for Brent Miller, appeal number 128341. Being the appeal to the Assessment Appeals Commission. I have an order on the motion of continuance. I have a August 11th, 2020 document for the Davidson County pre-hearing brief. I've got a July 30th, 2020 notice of hearing. I've got a May 1st, 2020 acknowledgement letter. I've got an April 30th, 2020 taxpayer supporting document for 2912 Tuggle measurements. I've got a 2020 April 30th taxpayer appeal for Brent Miller. The administrative record before the administrative law judge includes the March 26th, 2020 amended initial decision and order, the March 25th, 2020 initial decision and order, the March 25th hearing recording, the March 3rd hearing exhibits from 2020, the January 6th, 2020 notice of hearing, the October 21st initial appeal, the October 21st, 2019 initial appeal property record card, the October 21st taxpayer initial appeal notice of prorated assessment, and the October 21st, 2019 taxpayer initial appeal of similar document showing nearby similar sales. That said, I've read the initial decision and order. We then reviewed the changes that were in the amended initial decision and order, those documents otherwise being virtually identical. We then went over the notice of the administrative record and the record that is before the commission today. With that said, we can go ahead and get started. I will ask our parties to introduce themselves briefly, just say your name, and then we'll start with you, Mr. Bryant, as the taxpayer and appellant in these proceedings. So, Mr. Bryant, if you wouldn't mind introducing yourself to our commission members.
My name is Brent Miller.
I'm Brooke Thompson, an attorney representing the Davidson County Assessor's Office, and with me is Ms. Pam Ishii of the Davidson County Assessor's Office.
Before we fully begin, I guess I will ask the commission, do you have any questions at this time? All right, seeing or hearing none, Mr. Miller, the floor is yours. This is your opportunity for argument and explaining why you believe the administrative law judge's amended initial.
Probably guys know. I'm an attorney. I don't have an attorney. I'm looking at logically. Also, I want to point out, we're talking about 2019 here, not today, because things have changed since 2019. The short of it is, you know, I built this house myself. I know the square footage of it. I have a video tape. I tried to introduce it back in March when we were doing this, but my laptop wasn't working correctly. Plus, you have to remember, we were talking about March of 2020 when things got kind of chaotic. And they were just getting that chaotic at the time, but that's not really any kind of excuse. I put in right here, you know, the old square footage of the house. I entered this in 2020. All these, you can tell these papers are kind of old, but, and I'm going off old information, but there's nothing changed about the house since. I put in what the original house was, I put in the addition, and the addition I put in was 2 stories, so I just doubled that, okay? But then the upstairs was, you know, a couple of things in regards to a house. When you build upstairs, you got leaning in roofs, so your upstairs is not as big as your downstairs is. Also, I also contend, I might be doing this in the wrong order, but I'm just gonna give my argument here. The upstairs footage is not worth as much value wise as downstairs footage. You have to go upstairs to do it. And it lowers the value. Well, anyway, I went through and measured, I don't know if y'all have my evidence in front of you, but if you can refer to this page, you can see where I added up the square footage of the new addition. Then I doubled it. I took the old part of the house, and then I took what was of the upstairs and added it up. And basically came up to 1,674 square feet. I don't know if you all have this copy of this. I mean, I submitted this 3 or 4 years ago when we started this thing. I don't know if you have a copy or
So
not.
if you can reference it in that copy of the administrative record as one of those indexed exhibits, we can pull it up and show it as part of the
Well, it
record.
just says 29, well, toggle at the top. I didn't put, exhibit number, whatever on top of it. This page here, I'll show it to you if you need me to.
Sure, just hold on a moment. Right, I'm gonna share my screen. You can see on the video cameras. This was labeled as exhibit 2020.04.30, standing for April 30th, 2020, AAC taxpayer supporting documents. The
Yeah,
3-page. Right, this document is in the administrative record. Parties are allowed to reference parts of the record.
I tried to draw out the house best I could. Anyway, I came up with 1,600 by measuring, and you don't have time, you don't have 10 minutes time to waste, but basically there's a video in here. I'd be glad to show it to you if you're going to take 10 minutes. It's me measuring the outside of the house, going and measuring with the tape, me and another guy, and we videotaped it. The mistake I made, I thought, well, I could do it with 2 people. So I had to hold the tape and hold the camera too, which made it a little bit tricky. But there is like a 10-minute video of me running around the house, measuring each part of the house. And if you want to see it, I'd be glad to show it to you. It's on this laptop. But I will say, during the one back in March of 2020, it was malfunctioning. I couldn't get my laptop to work. Batteries, whatever the problem was. I couldn't get it to, I think I might have been trying to do it on my phone. I'm not really sure, but I did transfer it to this screen where it is much easier to see. And I'd be glad to show that if you want me to, but it's a 10-minute video, but it is on there. Okay, but let me go on with the other. If you want to see that, we can move on later. So I agree it's 1,674 square feet. They don't agree with that. They say it's much larger than that. We'll go with that. This exhibit, I don't know if you can put that up or not. The very first words is price per square foot in nearby properties. Based on some sales, I think. See that and put that up on the screen.
I can pull up the exhibits just a moment. These are the hearing exhibits, document labeled 2020.03.03 ALJ hearing. I have a 19-page document.
I'm gonna get to that part. That's the one.
This is labeled as Exhibit 6.
Yeah, that's, at the time, remember, we're talking about March of 2020, and I was going back to January 2020, some sales and stuff like that. And in the sales, the price per square foot in the sales I could get were, and you can see the addresses up there, sales in, they range from 178 in the highest per square foot to 130 to 129 per square foot. Okay, now I will offer you, if you look at the, 129 per square foot, 819 Live Oak, which is just across Thompson Lane from this property. 2,500, which is largest property, has the lowest value per square foot, which any realtor here, and you seem to be in real, you do know that when you get a twice a big house, your price per square foot goes down because houses just don't, you know, twice a big house in a neighborhood isn't worth twice as much. I'm very much considering that, you know, that you don't double the price of a house because it's twice as big, because there's still the lot and there's still a lot of other things to consider. And also upstairs footage is not worth what downstairs footage is. So, I came up to an average with that number of trying to do new construction, but there was a whole lot of houses that were at 130 per square foot, 140 per square foot, 129 per square foot, 42 per square foot. You see that on there. There's a few at 178, 176, 160, but I came up with an average. If you were to do it, you would do this, get the same number of $158 per square foot. Okay? That's what I came up with an average. Now, again, most of these houses are single story, so that is talking about the bottom floor there. Okay, so at the 1,674 square feet, from 158, I came up with $264,492 per square foot. Is my average, and then with all the measurements, which I have here. That's one of my arguments, and I'll move to the second one, which is what you were on before. If you could scroll back up again. Not that one. Well, that one shows it, but it's just much. Now, here, look at that. I mean,
Just
go to page 2, property 11 through 19.
I'm just gonna point out that this is exhibit 2 before the administrative law judge. And you want to go to what page of this document, Mr. Miller?
Page 2. I don't know if you can read. But this is the street it's on, okay? Okay, Tuggle Avenue. And we start at the house, this is 2912. You know, got 195,000. I'll do it really quickly because you don't want to hear the minutia of everything I have to say. The values on that street, 195,000, 183,000, 182,000, and then mine, 378,000. You're sticking 378,000 in amongst houses that are worth 190. And it's on the same size lot. You drive up the street, it doesn't look any different. The addition I put on the back, you know, it was a brick house, but the addition I put on the back is not brick. It's made out of, you know, I put hardy board on the side of it. Okay, and then you have mine at 378 and then 215, and there is a 262, a $119,000 house. Just 2 doors down is a $119,000 house. This is according to the tax records in January of 2019. And then 148,000 and another $120,000 house. There is no house. There's only 2 houses worth over 200,000. And they're saying mine's worth 378. Then a commercial rate on that house. My tax bill is like 4 times what anybody else's tax bill is on that same street. I think it's unfair. And if you, like I said, it isn't like you drive up the street and you see this great big column mansion house. It doesn't look any different than any other house on that street. And again, like I said, there's only 2 houses on the street at 200,000, over 200. Rest of them are in the 190, 180 range. Then they got mine at 378. It's unfair.
All right, with that, we'll hand over, also, if there's any questions from the commission. Hearing and seeing none, we'll hand it over to David for any argument.
Thank you. I would begin by saying, he just mentioned that it was on at 378. That's not accurate. The initial decision in order at the suggestion of the Davidson County Assessor's Office has it valued at 320,000. So the Assessor's Office agreed to the extent that it should be lowered to that amount. The taxpayer in this appeal is effectively asking for a de novo review of the appeal heard by the administrative judge. But as you know, the statute controlling appeals to the commission limits that to 4 factors that are set out in TCA 67-5-1506 that Mr. Pope read as we were getting started. The taxpayer is seeking to relitigate the issues argued, heard, and decided by the administrative judge. While the taxpayer disagrees with the conclusions of the administrative judge, the purpose of that evidentiary hearing was to afford both parties to the appeal the opportunity to present evidence and have the administrative judge, as the trier of fact, weigh the evidence and render a decision. In this appeal, the administrative judge did just that. He weighed the evidence. He found that the evidence presented by the taxpayer was not sufficient to cause a reduction in value further than what the assessor had suggested. He specifically said that the comparable sales that the taxpayer had introduced were not adjusted in the appropriate manner and therefore were not properly to be considered. Conversely, the comparable sales that the assessor's office introduced were properly adjusted and were compelling to the administrative judge. The taxpayer is essentially arguing that the administrative judge did not weigh the evidence properly. However, in each instance, the initial order sets out the arguments of both sides, weighs the evidence, and comes to a reasonable conclusion. As noted above, the taxpayer is not entitled to have the Assessment Appeals Commission substitute its judgment for that of the administrative judge. Finally, nothing in the record suggested any violation of any statute has occurred. The administrative judge clearly considered and weighed the evidence submitted by both parties and determined which side had met the burden of proof. The taxpayer has not stated any statutorily acceptable basis for the commission to alter the findings and conclusions of the administrative judge, and to do so at this point would be to substitute your judgment for that of the hearing examiner as to the weight of the evidence as to the questions of fact. Therefore, we ask that you affirm what the administrative judge has found.
Are there any questions from our commission members? Davidson. At this time, I'll ask Mr. Miller if you have anything additional.
As a realtor, you got a house you're gonna try to sell at 378,000, which is the time is what I was arguing. Now, I agree, they came down a little bit to 322, which is still way more than all the other houses. All the other house right across the street's $180,000 house. 2 doors down, $120,000 house, according to the tax appraisal. Now, I did do the comparable sales. You had those up there, and I came up with $158 a square foot. But realtors, are you gonna try to sell a house for 300 and whatever? It was 378 when I argued it. They did come down some to 322, not denying that. When it got a 2 doors down, a house that doesn't really look much different at 120,000. That's my argument is it's not fairly priced. I mean, the house doesn't look any different than any other house in the neighborhood. It is a little bigger because I added on, you know, and I added on a 14 by 22 addition to the back. That maybe makes it a little bit different. And it is a little bigger, but it is a little bigger because, you know, I made 2-story. But I added it, I did all this work myself, and that's an argument. Bear in mind, in this argument, I didn't get to weigh in on, you know, these decisions were made after I left. It wasn't came up to, and we came up to an agreement, and I said, okay, you know, he just said, hey, I'll take it under advisement. Left. This is what I came back with later.
Final questions from our commission members of Mr. Miller or Davidson County.
Does the assessor agree with sales that Mr. Miller has presented? as far as being market sales.
The assessor's office doesn't believe that the sales that the taxpayer presented have been adjusted properly, and therefore they are not relevant to the value of the property.
But the assessor does agree they were market sales.
I don't, at the time of the hearing,
There's
they,
nothing in the sale that would let you know that this is not a fair sale.
I don't know that we can answer that. At the time of the hearing, since they hadn't been adjusted, the assessor's office argued that they were not relevant to the value of the property. And I don't know that the assessor's office did a review to find out if they were indeed arm's length transactions or not. But because they hadn't been adjusted, the assessor's office didn't think they should be considered.
You mean it's adjusted as far as size and effective age and
Yes, sir, all the adjustments.
condition, and all that's been addressed on say, a 1004 form, probably.
Correct. When the assessor's office presented their comparable sales, they were adjusted in the appropriate manner to compare them to the subject property. The
So-
taxpayers did not have any
Okay.
adjusted sales.
Beyond the adjustments, which are necessary and are required, of the final value that it was determined by the assessor, does it represent the neighborhood?
Oh, certainly the assessor believes that it represents the neighborhood. That's why they used the comparable sales that they did, and that's why they adjusted them in the manner in which they adjusted them. It certainly came from the same geographical neighborhood. May not the exact neighborhood, but they came from the same geographical area.
Does it have a different area of the house than the taxpayer?
I'm sorry, I didn't hear that.
Does the assessor have a different size for this house?
The
than what
the assessor's square footage is indeed a little higher than the taxpayer is alleging. Taxpayer says 1,674 feet. The assessor has it on a 22091. The assessor's office offered to go out and measure it, but the taxpayer would not let them do that. And I would point out that the assessor's office always measures from the outside, and the taxpayer's documents that he has submitted here appear to be internal measurements for the improvement.
What was the assessor's size final?
2091. And I would point out that the same arguments about the size of the improvement were made before the administrative judge. He took all that into account and found that the assessor's proof was compelling.
There is a significant difference in sizes, these 10% of what he's saying. I don't know. To me, I think that's one thing we ought to at least get right.
So I will,
How big is the house?
Well,
Commissioner Bowles, I will suggest that we are not finding any facts today. We're not making a factual determination. However, if the commission does decide that that is unaddressed and needs to be addressed in this decision, they can remand it to the judge to make that factual finding.
Can I just point out that the judge addressed that in his initial decision in order and said that the taxpayer had brought that up and found that the assessor's proof was compelling in this matter. So the amended decision in order cites the taxpayer's drawing of square footage of the square property as one of the things that he is arguing about. But the amended decision in order goes on to say that the taxpayer's proof is not a reliable indicator of the value of the property. I mean, the last paragraph of the order before the order itself says, respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. I think that means both the comparable sales and the square footage, because it appears measured from the inside on these diagrams that were submitted to the administrative judge and not from the outside. But in any event, the administrative judge considered what the taxpayer had to offer and found that the assessor's proof was more reliable on all these issues.
Are there any other questions?
That was the square footage.
I apologize. I'm just going to interrupt here for just a little bit of clarification. I need to both know what exhibit you're referring to. If you could just show it to me again. I'll highlight it for. I'm gonna have this as the part of the text filing with the record. Hear that now. Screen document.
Yes, please.
Just to be clear, we're not hearing testimony or answers about facts, but the administrative law judge it or not address this exhibit. We'll this question.
Not an issue with it. Quite significant number. Taxpayers, 1664,
74.
something, 1,000.
91.
Got this document here, that's 1591. All I'm doing is just asking for steps were taken to.
So I would generally say that if you don't find that answer sufficient in either the administrative law judge's order, satisfied in the record, it's,
I didn't read it in the order.
yeah, and so if you find that to be deficient, we're not taking testimony today, so the parties can't exactly answer factual questions. But if you think that the judge needs to make that a factual finding and it's part of their decision, demand it to the judge to basically conduct that hearing, make sure they have a factual finding in the square footage, ultimately rule the value of that property.
I mean, the assessor's proof in this matter has an official sketch from the official assessor's records. Is on page 6 of the assessor's proof that was submitted to the administrative judge.
At the moment, I'm gonna pull that up again. I have our exhibits and document included in this packet. Or if you reference the document on administrative record.
It's titled Value Estimate Justification, and it's the one packet I think that the assessor's office presented to the administrative judge at the administrative hearing.
Right. So in our index of our administrative record, I have our March 26th amended decision order, March 25th initial decision order, the hearing reporting, and hearing exhibit. Do you know what?
6.
PDF. Is perhaps this document you're referring to in the back? Yeah, so I have this as page 15 of the document that's listed in our index as 2020 03.03-ALJ-hearing exhibit. This is part of the exhibits included with the administrative law judge. The initial decision order, everything this. And exhibit 7, the assessor's office evaluation analysis, is that correct?
Yes, yes. And I would out that these numbers for the square footage that appear to be on the one you asked about, said 1591, may very well have been the one square footage. There was a renovation which precipitated a prorated value, which is why we're here on the value of the property. So it's very possible that on 1/1/2019, that was the square footage or somewhere around there. But there was a renovation that increased the square footage, which was the subject of the appeal, which is why it's more than it was on what you saw. What you're seeing behind me now is from the official records of the assessor's office that was submitted at the hearing, which comes to 2,091 square feet.
Just reading of its previous administrative law judge, we have a sketch of the building and a breakdown of the living area. It does say main level, original house, 7 feet by 31. Finish upstairs, original house, square feet by 5 square feet, 500 2019 two-story addition, 700 area as of May 1st, 2019. 2000.
That's right, Your Honor. There was a renovation that occurred, which increased the square footage, which led to the prorated value, which led to the appeal that the taxpayer filed. The judge, the administrative judge, was given this evidence at the administrative hearing, weighed this, and found that this was the correct valuation of the property.
I have,
Uh, so we're, generally speaking, we're not taking testimony and the commission are answering questions here. Got a procedural question, you can ask it to me.
they're talking about adjusted values and they're throwing out my stuff because it's not been adjusted. Yes. Adjusted mean, I've sales of other properties, when they were sold, how big they were, how big they were. Price. Sure, what kind of- they said, well, we didn't take that because it wasn't adjusted. Not sure what adjusted means. This price that houses had sold for in that, in several months, in close to that. Multiplied how much they sold for by how many square feet they were. Price. Sounds like it was adjusted. I would adjust it.
Yeah.
Adjusted is what I think it is.
I guess I'll just generally respond just for informational purposes. Generally speaking, and don't necessarily maybe quote me on this, but for appraisal purposes, investments will adjust for square footage size, date of the sale of that property. So for instance, the sale sold in January might be sold for less than it was sold in May of that year, as well as there was financing involved, and so they will that out, as well as maybe trim level of the interiors of the home and other factors. Those would be adjustments you would make to comparable sales in order to make sure that you were comparing apples to apples with one property to it. So if you're asking just generally speaking what adjustments mean, I'm happy to generally illustrate that concept if that helps you.
But I would suggest that that's exactly why the administrative judge found the way he did, that the assessor's sales were more.
Adding. Yeah.
That's right.
So I will quote for our administrative law decision order as well. I believe he bolded this as well on page 3 of that order. The assessor's offices, it's the final paragraph on page 3 of at least the initial decision order. The assessor's offices properly adjusted in bold comparable sales were more reliable than the comparable sales presented by the taxpayer. So again, I remind you of the statute that says the commission is not to replace their judgment, questions of fact, but may take in light of all the evidence. I'll do one final call for any questions for commission members. That then I will, as soon as the commission is ready, I'll hand over. Y'all ready to enter? sorry, just to be clear, we're now entering deliberations. There'll be no more communication between the parties. If you have any other substantive questions, feel free. But just make, you have to speak a little bit louder and into the microphones. Thank you.
Sure. It's addressed at the ALJ hearing. In question, but I ought to take a look at this property and identify what the square footage of it is. A difficult task, but
I'm actually, excuse me one moment, please. Based on the data presented and what I reviewed and based on just experience and good old fashioned common sense, 1+1 = 2. I think the square footage as presented by the assessor is fairly accurate. If we take the base square footage prior to the addition, we take his mathematics, his addition, their addition, and we look at them, we're getting pretty close. I don't have an issue with it. I'm comfortable with it. There are other things that I understand my charge is not to address as data presented by the taxpayer. But I'm comfortable with it, and I want to ask Mr. Secretary, how do I move forward?
Yeah, so generally speaking, we can do an order, or sorry, excuse me, a motion. So you would ask if there is a motion to either uphold the administrative law judge's order, or if there is any other motion to remand for further proceedings, consideration, or if you otherwise want to reverse the decision of the administrative law judge. Generally speaking, any member can make a motion. Once motioned, you would ask for a second. If properly seconded, you can discuss that motion and any benefits and or pitfalls of it. Members may choose to amend that motion. And then once the considerations of the motion has concluded, you can do a voice vote on that motion. So I guess, do any of the commissioner members have a motion as to the outcome of this? So I have.
Do we have a second? Do we have a second?
Yeah,
You can also second.
I'll second it.
That I'll call for, unless there's any other amendments or discussion on the motion as presented to reaffirm, I have Mr. Osborne's motion as to affirm the amended initial decision for the administrative law judge. Any other discussion? Mr. Bowles, I just want to confirm.
yeah, no, I don't. Everything is black and white at this point. That's just a matter of 417 feet different. This house. Give me a dollar a foot, that's but saying that what the assessor has done correct, then have to affirm the decision.
Right, so all in favor of the motion as seconded, again, that motion being to affirm the decision of the administrative law judge, all in favor, say aye.
Aye.
Any nays? All three ayes, the ayes have it. The decision of the amended initial decision of the administrative law judge in this case is approved and affirmed by the Assessment Appeals Commission. So for the parties, I will say, we will send you a written order confirming the decision of the commission made today within the next 90 days. From there, it will explain any other further appeal rights you may have. Business for today is concluded.
thank you.
At this point in time, I'll ask our commission members, does anyone need a short break? All right, we're going to take just a 10-minute break here. So for our online participants, I'm not going to end the Zoom or end the WebEx at all. We will continue to keep it operating, and just to make sure we don't dislodge anything, we'll also continue to have the hearing recorded. I may mute this room temporarily during our 10-minute break, but we'll come back right at 10:10. Thank you.
Feel it's unfair.
All right. All right, and we're back. I have 10:10 on the clock. Test. Okay, it looks like our audio is working from what I can tell online. We'll go ahead and get started. Our next appeal for this morning will be for St. George Coptic Orthodox Church. Let's see, we still have everyone online. I'm going to start the same way we did as our last appeal by reading a copy of the initial decision in order in this case. And I will go over the acknowledgement of appeal that was sent out in April 2022. So I have this case entitled in regards to the St. George Coptic Orthodox Church with several property IDs. Property ID 11905007600, 11905007700, 11905007800, 11905022400, 11905022500, and 119050230. This is a claim of an exemption, so this is not a value appeal, but rather an appeal of an initial determination made of our office that was then appealed to an administrative law judge, and then finally has now been appealed to the Assessment Appeals Commission. This is for a Davidson County property. The exemption record numbers 175997, 175998, 175999, 17600, 1760001, 1760002, and the initial decision in order reads as follows. Statement of the case. This is an appeal pursuant to Tennessee Code Annotated Section 67-5-212, subsection B, subpart 2, from the initial determination of an application for exemption of the subject property from ad valorem taxation. The application was filed with the State Board of Equalization, hereinafter State Board, on February 23rd, 2021, in a letter dated March 17th, 2021. State Board Staff Attorney Emily Bennett notified the applicant, St. George Coptic Orthodox Church, hereinafter appellant, that as a result of a review of the file, the application for exemption was approved effective January 1, 2021. The appellant, contesting the effective date of the exemption, timely filed this appeal with the State Board on July 8, 2021. The undersigned administrative law judge, Jerome Cochran, conducted a telephonic hearing of this matter on January 12th, 2022. The appellant was represented by, and I apologize if I mispronounce this name, I have Serapion Gobriel, the priest of the church. Gobriel, thank you. The priest of the church. The Davidson County Assessor of Property was represented by staff appraisers Christina Ratcliffe, Brittany Hayes, and John Cantrell. Page 2, findings of fact and conclusions of law. The subject property of this appeal is a church located at 2412 Foster Avenue in Nashville, Tennessee. The property was acquired by the appellant on January 15th, 2020. Article 2, Section 28 of the Tennessee Constitution permits, but does not require, the legislature to exempt from taxation property which is, quote, held and used for purposes purely religious, charitable, scientific, literary, or educational, end quote. Tennessee Code Annotated, Section 67-5-212, subsection A, subpart 1, provides that there shall be exempt from property taxation the real and personal property or any part of the real or personal property owned by any religious, charitable, and scientific or nonprofit educational institution that is occupied and actually used by such institution for its officers purely and exclusively for carrying out one or more of the exempt purposes for which the institution was created. There shall further be exempt from property taxation the property or any part of the property owned by an exempt institution that is occupied and actually used by another exempt institution for one or more of the exempt purposes for which it was created or exists under an arrangement in which the owning institution receives no more rent than a reasonably allocated share of the cost of use, excluding the cost of capital improvements, debt service, depreciation, and interest as determined by the Board of Equalization. I will just note perhaps too that that statute has been updated since this administrative law judge's orders quotation. Continuing on, in Tennessee, contrary to most other states, property tax exemptions are liberally construed in favor of religious, charitable, scientific, and nonprofit educational institutions. Then cites Youth Programs Incorporated versus Tennessee State Board of Equalization. Nonetheless, as the party appealing the initial determination on its application for exemption, the appellant has the burden of proof in this administrative proceeding, State Board Rule 0600-1-.11, subsection 2. In the original application for exemption that was filed on February 23rd, 2021, it was stated that use of the property by the church began on January 15th, 2020. The State Board of Equalization granted an exemption starting on January 1st, 2021. The appellant testified that he nor the church were aware that they need to apply for tax exemption as a church, and once they discovered they were required to, they immediately did apply. In determining the appropriate effective date of the exemption, the state board's designee relied on Tennessee Code Annotated, section 67-5-212, subsection B, subpart 3, subsection A, which says in pertinent part, any institution claiming an exemption under this section that has not previously filed an application for and been granted an exemption for a parcel must file an application for exemption with the State Board of Equalization by May 20th of the year for which exemption is sought. If the application is approved, the exemption will be effective as of January 1 of the year of application, or as of the date the exempt use of such parcel began, whichever is later. If application is made after May 20th of the year for which exemption is sought, but prior to the end of the year, the application may be approved, but will be effective for only a portion of the year determined as follows. Regrettably, at the hearing, no additional proof was offered to establish an earlier effective date. Indeed, the appellant confirmed they did not file for an exemption in 2020. Unfortunately, the administrative law judge, quote, cannot disregard or rewrite the conditions for property tax exemption imposed by law to accommodate even the worthiest of causes, end quote. Then cites in a footnote, ICM Foundation initial decision and order, Davidson County, issued October 4th, 2004. For these reasons, the administrative judge is compelled to affirm the effective date established by the state board. Order. It is therefore ordered that the initial determination of the state board staff attorney be affirmed and the effective exemption date is January 1, 2021. The order then continues to cite on the bottom of page 3 and onto the top of page 4, the appeal remedies available to the parties before signing the order effective January 20th, 2022. The final page being a certificate of service. That will also move on to the administrative record. So on April 28th, 2022, an acknowledgement of appeal was sent to the parties on this appeal. On February 17th, 2022, FR Sarabian filed an appeal of the initial decision and order issued by Administrative Judge Jerome Cochran on January 20th, 2022. A copy of this filing has been included as Exhibit 1. A hearing of the appeal before the Assessment Appeals Commission will be set at a future time and date, and the parties will receive a copy of the notice with all relevant information in advance of the hearing. The Commission meets a limited number of times each year, and the dates available for hearing this appeal are limited. If you have not already prepared for this hearing, you should do so immediately. Pursuant to Tennessee Code Annotated Section 67-5-1506, the Commission's review of this matter is limited to the existing administrative record. A copy of the administrative record as of the date of this acknowledgement will be shared with you you electronically. An index of all the items currently comprising the administrative record is included as Exhibit 2. If you believe any documents or other items are missing from the administrative record, you must send a brief explanation and a copy of the missing items to the Executive Secretary of the State Board of Equalization as soon as possible. This document then continues with Exhibit 1 being the taxpayer appellant in our scenario, written arguments with regards to the initial decision order and their basis for appeal, along with exhibits to their written arguments. We then continue through, it also includes a copy of their digital printout of their appeal filing. And then Exhibit 2 is a copy of the index of the administrative record. A copy of this was sent to email via Microsoft OneDrive to the email addresses listed. The index of the administrative record for this appeal, including all those appeal numbers I read previously, are the SmartFile AAC appeal, being the taxpayer's letter for appeal, their online appeal filing, the documents submitted to the administrative law judge, including an order denying reconsideration issued on February 4th, 2022, a reconsideration email on February 2nd, 2022, the initial decision order issued on January 20th, 2022, notice of hearing on September 19th, 2021, the corrected notice of hearing on September 19th, 2021, a notice of scheduling conference on October 8th, 2021, appeal of the initial determination on June 6th, 2022, June 22nd, 2021, the initial determination issued on March 17th, 2021, the assessor's review for several parcels all issued on March 11th, 2021, the request for an assessor's review on March 1st, 2021, photos of 2404 Foster Avenue, photos of 2402 Foster Avenue, and photo of 2400 Foster Avenue, all of those from February 23rd, 2021, a photo of 113 J Street, a photo of 111 J Street, a photo of 110 Alberta, all those as well on February 23rd, 2021, church bylaws, a document just labeled 501c3, and the initial applications, all of those again on February 23rd, 2021. So I've recited a copy of the initial decision order that's subject to being reviewed by the commission today, as well as summarize those documents that are that comprise the administrative record in this appeal. With that said, I will now ask our parties to introduce themselves to our commission members. We'll start with the taxpayer. Please introduce yourself to the commission.
Father Serapion Gabriel, the priest of St. George Church.
All right, and I'll ask the representative for Davidson County, introduce yourself.
Good morning. My name is Lexi Ward. I'm with Metro Legal.
With that, we're still on the record. Everything's concluded, so we'll hand it over to the taxpayer for introduction of your arguments as to why you believe this administrative law decisions order was otherwise incorrect.
Yeah, we were not aware for that the additional property has to be filed because we may think that this property is automatically related to the church, so it is tax exempted. But when we receive the taxes for this property, we begin to file it on 2021, and we took actually the exemption for these properties, but we do need to do it for 2020, especially this year is coronavirus year, and the church is not opened for months, and when it is opened, it was with about 10% of the whole congregation. So the income of the church was very, very low at this year.
All right, any questions from the commission at this time? All right, I will admit, I do have a physical copy of the initial decision order. I'm going to hand that out to you now. I apologize if I didn't do that earlier. No questions from the commission. Ms. Ward, I will refer to you for your argument.
Thank you. Good morning again. Unfortunately, today the taxpayer provides no basis for reconsideration by this commission. And as Robin has stated earlier, under the current standard of review, this commission may not consider any new evidence at this time and is limited to determining whether the ALJ's decision was proper under the circumstances, supported by the evidence, and not arbitrary or capricious. Here, the taxpayer's asserted reason for the appeal is requesting an earlier effective date and asks this commission to render a more favorable opinion with a different effective date, but that would essentially substitute this commission's judgment for that of the ALJ against the standard that this commission is charged with. So therefore, this remedy is unavailable. This commission is tasked with solely determining whether the ALJ's decision is based upon substantial and material evidence, and indeed it was. The ALJ made a proper determination under TCA 675212 by upholding the effective date given under the statute. Because the taxpayer was successful in applying by the May 20th statutory deadline, the statute requires that the effective date be January 1st of that year, which was 2021. Unfortunately, the statute does not permit an effective date to be granted in years prior to the application. In order to backdate an effective start date into year 2020, the application was required to be filed in tax year 2020. And by admission, that was not done in this case, unfortunately. Therefore, because the ALJ came to the correct conclusion under the statute based on the evidence, this commission should affirm the initial decision and order.
Any questions from our commission members? All right, I'll ask, again, apologize if I mispronounce this, Mr. Gohobrial, if you have any other response, you're welcome to go now.
Yeah, as I know by Tennessee law that any property related to exemption property should be exempted too. So even it is prior to application we send, but it should be exempted because it is related to the church and the church has tax exemption and the 501c. Thank you.
Thank you. Any other final questions from our commission members? Seeing and hearing none, we'll then otherwise enter deliberations. Again, Mr. Turner, you'll start our presiding member for today. Welcome to talk openly, and if anyone has a motion, you may make a motion in second and then deliberate on that motion as well.
Does anyone have any questions or comments?
What did they do?
Commissioners?
Just missed the filing date? Trying to get it. I couldn't understand it that well.
So I can refer back to the administrative law judge's order on page, bottom of page 2, the final paragraph. It states, in the original application for exemption that was filed on February 23rd, 2021, it was the use of the property began on January 15th, 2020. The State Board of Equalization granted an exemption starting on January 1, 2021. The appellant testified that neither he nor the church were aware that they need to apply for tax exemption as a church. And once they discovered they were required to, they immediately did apply. Then on continuing page 3, he cites the statute that shows the effective date, that being what exemptions are to begin according to the law, and has bolded. I will read from that statutory section here that is cited on, again, at top of page 3. Any institution claiming an exemption under this section that has not previously filed an application for and been granted an exemption for a parcel must file an application for exemption with the State Board of Equalization by May 20th of the year for which exemption is sought. If the application is approved, the exemption will be effective as of January 1 of the year of application, and then he puts in bold, or as of the date the exempt use of such parcel began, whichever is later. If application is made after May 20th of the year for which exemption is sought, but prior to the end of the year, the application may be approved, but will be effective for only a portion of the year determined as follows. Yes, and then continues on. Regrettably, at the hearing, no additional proof was offered to establish an earlier effective date. Indeed, the appellant confirmed they did not file for an exemption in 2020. Unfortunately, the administrative law judge, quote, cannot disregard or rewrite the conditions for property tax exemption imposed by law to accommodate even the worthiest of causes, end quote. Any other, I guess, questions on that? And you're still in deliberations. I just recited part of the administrative law judge's decision and pointed that. What?
Hearing no further questions or comments, do I have a motion to approve the administrative law judge's decision?
I make a motion.
I second.
All right, seconded by both Mr. Osborne and Mr. Turner. The motion is properly before the commission, that motion being to affirm the initial decision and order of the administrative law judge. Any discussion on that motion? Hearing and seeing none, all in favor, say aye.
Aye.
All opposed? The ayes have it, with all three commission members voting aye. That otherwise disposes of our appeal for St. George Coptic Orthodox Church this morning. Written order will be sent to the parties within the next 90 days. Otherwise, your business is concluded and you're welcome to disconnect from the Teams call and go about your business for today. Thank you.
Okay, thank you.
So we're just gonna pause for a moment, let those callers end, and we'll proceed with our next and final appeal for today, being TK of Clarksville. I'm gonna allow a moment to see if our Montgomery County Assessor's Office wants to take their seats before the commission. I do have that our taxpayer representative, Mr. Jay Catnany, is appearing remotely for the commission. Okay. I'll go ahead and get started with this being our final appeal. I've got a copy of the official decision in order. I'll pass out to our commission members. Make sure we're all reviewing the same documents again. I will read this decision. We have this appeal entitled in regard to TK of Clarksville LLC, property ID 032-111-00000 for tax years 2020 and 2021. I will note for the record, the taxpayer previously filed a request to amend this appeal to carry forward the value for tax year 2022. So the decision of the commission today will apply to tax years 2020 through 2022. This is a Montgomery County appeal, appeal number 131411. Initial decision order, statement of the case. The Montgomery County Board of Equalization, hereinafter local board, has valued the subject property for 2020 tax purposes as follows. A land value of $1,123,000, an improvement value of $1,219,600, total value of $2,342,600, and an assessment value of $937.40. The Montgomery County Assessor of Property has valued the subject property for 2021 tax purposes as follows. I will just note that those numbers are identical and the same. Taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, on July 30th, 2020. the taxpayer's June 3rd, 2021 request to amend this appeal to include tax year 2021 has been granted. The undersigned administrative judge conducted a hearing on this matter on January 20th, 2022 in Nashville, Davidson County, Tennessee. The appellant, TK of Clarksville Incorporated, was represented by its tax representative, Jay Catanani, at the hearing, hereinafter the taxpayer. The Montgomery County Assessor of Property was represented by staff representatives Cheryl Lonergan, Barry Easley, and Michael Hind, hereinafter the assessor's office. Summary of the evidence. The testimony of the parties and the following exhibits were introduced and considered during the hearing. Exhibit 1, the taxpayer's valuation analysis. Exhibit 2, the taxpayer's rent comparables. Exhibit 3, the assessor's office's valuation analysis. Exhibit 4, the assessor's office's list of comparable restaurants. Exhibit 5, Buffalo Wild Wings comparable information. Exhibit 6, the assessor's office's retail comparables. Exhibit 7, Rock and Roll Sushi comparable information. Exhibit 8, the assessor's office's comparable leases. And Exhibit 9, Lowe's initial order. Findings of fact and conclusions of law. The subject property consists of approximately 7,934 square foot building built in 2012, located at 2790B Wilma Rudolph Boulevard in Clarksville, Tennessee. The subject property contains 2.1 acres. The taxpayer contended that the subject property should be valued at $1,840,000 for tax years 2020 and $1,720,500 for tax year 2021. The assessor's office contended that the value placed on the subject property by the local Board of Equalization for 2020 of $2,342,600 should be affirmed and further should also be adopted for tax year 2021. The basis of valuation set out in Tennessee Code Annotated, section 67-5-601 subsection A is that, quote, the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values, end quote. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding, State Board Rule 0600-1-.11 subsection 1. At the hearing, the taxpayer representative testified that the subject property contained a theme restaurant that was built in 2012. The taxpayer based its valuation on the income approach using information derived from CoStar. The relevant tax years, the subject property had a triple net lease with a blended capitalization rate of 7.75% and a 5% management fee. He also testified that the property was treated as a second-tier property due to no name recognition for the property. The taxpayer's valuation analysis also included a sale approach that had a value of $1,836,000. The taxpayer chose to adopt the higher value from the income approach. Under cross-examination, the taxpayer testified that the leased outdoor porch area was given a reduced value under his analysis due to it being an overflow area with roll-up doors and having no central heat and air. The assessor's office's witness, Cheryl Lonergan, testified that the assessor's office's valuation analysis was more reliable than the valuation by the taxpayer. She further testified that the subject property's location is highly sought-out market area due to its proximity near the mall. She also testified that most restaurants are built for a specific restaurant and never lease, and that COVID did not affect property values. Ms. Lonergan testified regarding the taxpayer's income approach being unreliable due to the higher capitalization rate and that she believed the taxpayer increased due to COVID. She further testified that the taxpayer's reliance on estimated rents from CoStar made the income approach by the taxpayer unreliable. She also testified that the taxpayer's sales approach was also unreliable due the comparable sales relied on by the taxpayer were not good comparable properties due to their location, construction quality, sales price, uses, and age of sale. She further testified that the taxpayer did not adjust the comparable sales for age, construction quality, and location. The assessor's office believed the cost approach is more reliable than the preferred approach to valuation of restaurants, especially since no sales were available for comparison and considering the lack of provable leases for similar properties. The assessor's office testified that their cost approach analysis supported the value affirmed by the local board for the subject property. Under cross-examination, the assessor's office testified regarding the taxpayer's comparable sales. The assessor's office also disagreed with the taxpayer's contention that adjustments to the comparable properties were not necessary due to restaurants being a destination that people drive to. Further, the assessor's office disagreed with the taxpayer's contention that external obsolescence should be factored into the valuation due to COVID. With respect to the weighted approaches used by the taxpayer, I have concerns with their reliability. Based on the testimony and evidence, I believe that the assessor's office cost approach to be the more reliable method to value the subject property. The respect to the taxpayer's use of the sale prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as location, square footage, etc., were not taken into account in the comparable sales listed in their valuation analysis. So these comparable sales are not a reliable indicator of whether the land values are compared, what the land values are compared to the subject property. The Assessment Appeals Commission has said that for comparable sales to be relevant, they must be properly adjusted. An E.B. Kissel Jr. final decision order, Shelby County tax years 1991, 1992, issued June 29, 1993. The commission said, the best evidence of the present value of a residential property is generally sales of property comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. Final decision order at 2, emphasis added. Based on the taxpayer's failure to use properly adjusted comparable sales, I find the taxpayer's comparable sales approach not reliable. I also have concerns with the taxpayer's income approach. I agree with the assessor's office that the taxpayer's income approach reliance on estimated leases and not provable leases are problematic when trying to determine the value of the subject property. While the cost approach may not be the preferred way to value an income-producing property of the evidence offered in this matter, the assessor's office's cost approach appears to be the most reliable and fairest way to determine the value of the subject property. He then notes at footnote 2, as the Assessment Appeals Commission has explained, quote, the cost approach is based on the appraisal principles of substitution, that a knowledgeable buyer would pay no more for a property than the cost to acquire similar construction improvements of equivalent desirability and utility without undue delay, end quote. He then cites the administrative law judge's order, or the orders from the State Board of Equalization for that footnote. And then notice finally, judge adopted modified cost approach valuation as the most reliable value evidence because of issues with the sales comparison and income approach analysis utilized by parties. Continuing on back into our final paragraph on page 5, their cost approach and used adjusted sales to determine land value and relied on Marshall and Swift valuation services to determine replacement costs. In the absence of any evidence introduced to contradict the adjusted land values or replacement costs presented by the assessor's office, I find they support the value of the subject property as affirmed by the local board. Further, the taxpayer failed to carry their burden of proof with respect to changing the value of the subject property as determined by the local board. Therefore, I am adopting the 2020 and valuation for tax year 2021 as well. It is therefore ordered that the following values be adopted for tax years 2020 and 2021. A land value of $1,123,000, an improvement value of $1,219,600, and a total value of $2,342,600 with an assessment of $937,040. The rest of page 6 cites the appeal remedies available to the parties. And finally, on page 7, we have the signature that this order was issued on March 22nd, 2020. I will also move over to our Instead of doing our notice acknowledgement of appeal, I will cite from the notice of hearing for this matter. We have a several page document that was issued on August 12th, 2020. I have 1, 2, 3, 4, and on page 5, we have a copy of a notice of the index of the administrative record for TK of Clarksville LLC, appeal number 1311411. The administrative record as of August 12th, 2022 consists of the record of appeal to the Assessment Appeals Commission, that being the May 18th, 2020 taxpayer motion to include tax year 2022, the May 16th TK Clarksville acknowledgement of appeal issued by our office here in the State Board of Equalization, and the April 20th, 2022 taxpayer appeal to the commission. The rest of the administrative record includes the ALJ order denying the petition for reconsideration, the assessor's rebuttal of the petition for reconsideration, the taxpayer's petition for reconsideration, the initial decision and order that I just read, the hearing recording of the hearing for this appeal, hearing exhibits 1, 2, 3, 4, 5, 6, 7, 8, 9, as well as the ALJ notice of hearing, the original taxpayer request to amend the appeal to include tax year 2021, and the July 8th, 2020 County Board of Equalization letter. With that said, I've recited the administrative record before the board, as well as a copy of the initial decision order that's for review for today. That I will ask our appellant, which I believe to be Mr. Catnany in these proceedings. So Mr. Catnany, please introduce yourself, and then I'll have the county introduce themselves.
I'm Jay Catnany. I represent the taxpayer. I'm a registered agent with the State Board of Equalization and a certified general real estate appraiser with the state of Tennessee.
All right, and then I will ask Montgomery County, identify who's going to be representing your appeal this morning.
My name is Cheryl Lonergan. I work with Montgomery County Assessment Property and Commission Department.
My name is Barry Easley. I'm also with Montgomery County and Commercial Valuation.
All right, with that, unless there's any preliminary questions from our Assessment Appeals Commission. Hearing and seeing none, Mr. Catnany, the floor is yours. You're welcome to begin your argument about why you believe the administrative law judge's decision was incorrectly decided.
Thank you, Mr. Chairman. Members of the commission, I don't know if you've got my petition for reconsideration in there, but I do have it in front of me, and I will just read some of the findings, the conflicts with finding of facts. I know you probably don't have it in front of you. This with regard to my sales comparison approach, and I'll just read from his decision with respect to the taxpayer's use of sales prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as location, square footage, et cetera, were not taken into account in the comparable sales list in the valuation. So these comparable sales are not a reliable indicator of what the land values are compared to the subject property. My response to this was all the sales were adjusted for appreciation, which was not mentioned in the initial decision in order. The personal property was adjusted for each sale. That was not mentioned in the judge's order. All of the sales were similar in age and condition. An adjustment factor for this was not warranted. The average of the 4 sales that I included, which were Demos, Ruby Tuesdays, Golden Corral, and King's Privilege, the average of the 4 sales age was 2008 versus the subject's 2012 age. The Ruby Tuesday sale number 2 was originally built in 1998 and normally would require an adjustment for age and condition. However, this property previously sold on 12/18/2017 for $1.2 million and was remodeled prior to the new sale as shown in 2019 for $1,860,000. Thus making the effective age now closer to 2008. In summary, an adjustment for age condition was not warranted for the sales used since they were all similar in age. Likewise, an adjustment for land value location was not warranted between the subject and the comparables used. Sale number 3, which is the Golden Corral, and sale number 4, King Privilege, both had the same land value per square foot as subject. Sale number 2, Ruby Tuesdays, at $8.46 a square foot versus 1188 square foot for subject. However, an adjustment here was not warranted since the site is L-shaped and has 0.43 acres of unusable land, which using the smaller usable area then equates to $11.30 a square foot and or similar to the subject. Sale number one demo sold on 6/28/2019 for $1,805,000. The county's value for this property in the 2019 reappraisal the same year was $2.6 million, some $785,000 greater than the sale price. Thus, this improvement was overvalued. And then I go on to say and break down using their land to billion ratio about how to break it down. And at the end result, I'm not going to go into it. It works out to $10.51 a square foot and is in line with other sales land value and does not require an adjustment for location. Thus, the land values for all the comparables were equal across the board and did not require an adjustment. And the land values above being equal give credence to the taxpayer's contention with regard to being destination site and equal as demonstrated by the taxpayer in the county. And moving on to the income approach, in his comments in the initial decision in order, I also have concerns with the taxpayer's income approach. I agree with the assessor's office that taxpayer's income approach reliant on estimated leases and not probable leases are problematic when trying to determine the value of the subject property. As we all know, in the state of Tennessee, we're empowered as a fee simple state. To use actual leases and a probable lease would entail valuing the property as a lease fee estate, not fee simple. The taxpayer presented not one, not 5, but 17 lease estimates from CoStar from subject property. The 11th edition of the appraisal of real estate sites and fee simple valuations, all rentable space is assumed to be leased at market rent. No rental term to a specific lease is included in the income estimate. Market rent is the rental income of that property would at most probably command in the fair market value. Is then got the current rent paid and asked for comparable space as of the date of the appraisal. The appraiser estimates income and expenses after researching and analyzing the income and expense history of the subject property and income and expense histories of competitive property, recently signed leases, proposed leases, and asking rents for the subject and competitive property. Actual vacancy levels for the subject and competitive properties, management exemptions for the subject and competitive properties, published operating data and tax assessment policies, projected change in utility and tax. This is from the 11th edition. Further, I'll go on. In my income approach, it is my opinion that I did all this. Further, the administrative law judge, assessor's office disagreed with the taxpayer contention that external obsolescence should be factored into the value due to COVID. The taxpayer presented 27 pages from real estate experts across the country as to how COVID affected real estate. Not one mention of this was given in the administrative law judge's decision. The ALJ's simple statement that the assessor disagreed with the taxpayer contention that external obsolescence should not be factored into the valuation due to COVID violates TCA 67-5-1505, which creates a duty for hearing examiners of the state board to prepare findings of fact and conclusions based on receipt and consideration of all admissible evidence presented at hearing. The ALJ has failed to do this and extensively stated in his decision that the assessor disagreed. Davidson County has just finished their reappraisal in 2021 and adjusted depreciation on both restaurants and hotel motels for COVID. Given all the above, the taxpayer respectfully requests that the initial decision in order be vacated and the bills set to be reheard for each tax year 2021, 2020, 2021, and 2022. Thank you.
At this time, I'll ask if the commission has any further questions of Mr. Cattan. Okay, hearing and seeing none. When they're ready, you can begin. Just hold up a moment.
First of all,
All right, we ready? All right, go ahead.
First of all, Montgomery County would like to object to the addition of 2022 into the record. This is on the grounds of SBO Rule 600.01.10, subsection 2. It states that an original real property appeal timely filed to the board may be amended to include an assessment year or years subsequent to the year for which the original appeal was filed until the next reappraisal. There is a presumption of reasonable cause that when an original real property appeal has not been heard by the time the appellant is due to file an appeal for the subsequent assessment year. And SBOE Rule 600-01-1.13 subsection 2, hearing shall be based on the existing record, except that additional proof may be taken in cases involving alleged irregularities in procedures that are not shown in the record. The original appeal of this case was heard on January 20th of 2022. The initial decision and order was issued on March 22nd, 2022, and the order denying taxpayers' petition for reconsideration was issued on April 28th, 2022. This was all well before the county board hearing that took place in June of 2022. This hearing today is not the original appeal of this case, but merely review of the original appeal. There was no testimony provided by either party on the 2022 tax year value. Therefore, there's no record for which the commission can review 22. So we do object on that, the adding of 2022 and being reviewed.
Yeah, we can address that issue separately. So I have pulled up before the commission members a copy of our rule on amending appeals, which, as cited from Ms. Lonergan, does say an original real property appeal timely filed at the board may be amended to include an assessment year or years subsequent to the year for which the original appeal was filed until the next reappraisal. There is a presumption of reasonable cause when original real property has not been heard by the time the appellant is due to file an appeal for any subsequent year. The administrative judge, the commission, or the board may carry forward the original tax year adjudication of value into subsequent tax years within the same reappraisal cycle, but only if there has been no material change to the property, market conditions, or other circumstances or factors substantially impacting value. An original real property appeal filed late may be amended to include an assessment year or years subsequent to the year for which the appeal was filed until the next reappraisal, if the late appeal was nonetheless eligible for a reasonable cause determination and the written order disposing of the original appeal was entered later than 10 days before the deadline for appealing the subsequent year assessment to the county or state boards of equalization. All other requests shall lie within the discretion of the administrative judge. That is our rule for amending appeals to include subsequent tax years. It is in the discretion of the administrative judge, the commission, or the board to may carry forward the original tax year adjudication of value into subsequent years within that same reappraisal cycle. Mr. Catanini previously filed a request to amend to include to have this appeal to include tax year 2022. I have that included in our original administrative record. As I stated, it was filed with the commission on May 18th, 2022. Excuse me, Mr. Catanini, but I will pull up a copy of that original deal, and then I will explain the next steps that we're going to. Mr. Catanini, I'm not sure what you're doing, but can you just hold off for, there you go. All right, here's Mr. Catanini's original request. Dear Secretary Pope, pursuant to the rule of the board, we are requesting the above appeal be amended to include tax year 2022. As general grounds for this motion, we aver that the appeal to be amended was timely filed and not heard before the board before the time to file appeals for 2022. And again, this was filed on May 18th, 2022. We did not otherwise previously receive an objection from Montgomery County. So what we're going to do from here, the commission will decide whether they want to amend this appeal to include tax year 2022, or they have some other options they have available to them. We can hear from the parties first. First, I'm going to hear from Mr. Catanini to respond to your objection to include tax year 2022. Mr. Catanini, do you have anything to say on your request to include to have this appeal apply to tax year 2022?
No, Mr. Chairman. I think I did everything after the letter of the law to include tax year 2022.
All right, and Ms. Lonergan, you have something additional.
Yes, also in the SBOE 600.01.10 subsection 2, it does say the administrative judge, the commission, or the board may carry forward the original tax year adjudication of value into subsequent tax years within the same reappraisal cycle, but only if there has been no material change to the property, market conditions, or other circumstances or factors subsequently impacting value. Mr. Catnani is asking for COVID impact for 2021, and the fact that COVID impacting January 1st of 2021 and January 1st of 22 is very different. I would say that there is no reason for 2022 should have been argued on its own standing, because he is asking 2020, 2021 to have two different values. What value is he asking for 2022? And he has, again, the market conditions did change from January 2021 to January 1st of 2020.
So you are correct. We are not otherwise hearing any evidence or testimony on the valuation for tax year 2022. The commission could carry forward that valuation for tax year 2021 up through 2022. If you are contesting that there has been a change in the material change to the property, market conditions, or other circumstances or factors impacting that value, we will adjourn today's proceedings and we will reconvene, and I'll refer this to administrative law judge for consideration of that motion.
I would like to hear 2020 and 2021. Montgomery County, the practice of Montgomery County is to, if this decision is upheld and the value is upheld, Montgomery County carries forward that value. But if, and I'm not sure how this goes, if the commission decides to go with Mr. Catnani on his values, then Montgomery County would have an objection to that value of 2021 being carried forward to 2022 based on the market conditions that happened at that time.
Yeah, so the commission today is bound to only a couple different options. They can affirm that value by the judge and carry it forward to 2022, pending the resolution of your objection. They can remand the decision to administrative law judge, who will otherwise then also consider that 2022 amendment and that tax year separately. Or they can revert, so they can remand the decision to the administrative law judge for further consideration, or they can reverse the decision, which generally also includes a remand to the administrative law judge based upon what grounds they're reversing that decision. So with that said, generally speaking, since we're not hearing any new testimony on the value for tax year 2022, I would otherwise direct the commission that if, upon resolution of your objection, if 2022 is ultimately included, which will be in their discretion to include 2022 in the first place, they will only be required to carry it forward. We wouldn't hear testimony on the value for 2022. So basically, if the administrative law judge, for instance, if the administrative law judge decision is affirmed by the commission, then that value as ordered by the judge will apply through tax year 2022. We won't have any conditional testimony or evidence on it. If you as the county are contending that that value should be increased or decreased for tax year 22, or that there's been a material change as such, meaning that the tax year should not be amended in this case, that would be a factual determination. I'd have to send to an administrative law judge. We're not hearing facts and testimony, we're only reviewing that decision. I would adjourn today's proceedings and remand you to a judge for consideration of that factual element for the consideration of tax year 2022, and or we would have to adjourn and continue these proceedings to a future date where the commission could allow testimony and evidence for that. And that I didn't have notice that was going to be today's proceedings. We'd have to give Mr. Catnani an opportunity gather his evidence to present that there either has or has not been a material change to that property. So essentially, to summarize all that very quickly, I'm going to ask you: are you claiming that there's been a material change to the property, market conditions, or circumstances impacting today's value?
No, but said if it was.
Oh yeah. So I understand the assumption being if you are not go, if that is not the basis of your objection, I will avert to you that the clarity for today is I'm also directing the commission that include tax year 2022, which I will also ask them to officially include tax year 2022, that their decision today to uphold it and or to remand it to a judge will also apply to that subsequent tax year. But since you are correct, we are not hearing any evidence or testimony as to the value for tax year 2022. The board will be limited as per the rule to carry it forward through that reappraisal cycle. Does all that kind of track? All right, so with that said, are you okay if there's no evidentiary issues, I'll then ask the commission if they would like to grant the request to amend tax year 2022. That kind of make, okay. And Mr. Catton, I guess any other questions on that or response I need to ask before we move forward?
No, Your Honor.
That we're gonna briefly enter a sort of mini deliberations here. We'll have no more discussion between the parties and yourselves. So the question that we have before the commission that I'm gonna ask you to have a motion and rule on here is the commission, do you agree to accept the motion to amend tax year 2022 and carry forward the administrative law judge's determination through tax year 2022, knowing that at the end of this appeal, you may remand the entire decision back to the administrative law judge, reverse the decision, or otherwise affirm the value ordered in that initial decision order? So essentially, the question is, are we including 2022 today, and or does that need to be dealt with separately?
I don't know why you would bring it forward right now if she says the conditions change.
So not to misquote Ms. Largan, but I believe that we're saying the conditions have not changed. That was not the basis of their objection.
I misunderstood. I thought you mentioned COVID.
We would not otherwise have additional testimony or evidence on that tax year. The resolution of today's proceedings would just simply, that value would carry forward through tax year 2022. Sure. So the factors for not carrying that forward, and or for entering a evidentiary hearing would be if there was a material change to the property, market conditions, or other circumstances, factors substantially impacting value. With that, I might exit deliberations really quickly and just reaffirm, I just need a yes from you as well, Mr. Catnany. That is not the claim of this issue today. There's no issue with regards to tax year 22, that value being carried forward, as we're not accepting any evidence on value for 2022. It's just whether that's being carried or not. So I guess I need to know affirmatively, does Montgomery County claim that there are those circumstances, material change in the property, market conditions, or other circumstances or factor that would prevent the board or the commission from otherwise carrying forward the value for tax year 2022? And Mr. Catnany, is that also your contention?
Yes, Your Honor. It's kind of hypocritical in that the judge didn't apply anything for COVID, and then but yet they're saying don't carry it forward. But you know.
So yes, so I'm just going to offer here for state board practices, generally speaking, to maybe add some background for that. We have this rule that allows people to amend an appeal to include subsequent years. We are a reappraisal cycle state. So for instance, I believe in Montgomery County, your last reappraisal was the year of this appeal, 2020, is that correct? 2019, and your next reappraisal was 2024. Therefore, anyone appealing in Montgomery County they can appeal every year, and or if they appeal 1 year and they're still waiting on resolution of that case, they may amend to include subsequent years. Basically, as the rule does, essentially it's because if you are still waiting on a prior year, you don't know if you need to go to the county board yet or not for resolution on a subsequent year. And so you can amend your appeal before the board for every year, essentially at subject, until you get resolution on that year. The administrative law judge previously amended the appeal to include tax year 2021. From the time he appealed that, he appealed it to the commission. They would also like to include tax year 2022, being to carry forward that value. At evidentiary hearings before an administrative law judge, the parties might put on separate evidence for every discrete tax year, and otherwise determine a separate value for each year. I believe that, generally speaking, is the concern of Montgomery County, is that the commission will not otherwise be determining a new value for tax year 2022. I've kind of restated at the beginning of these proceedings, and we'll say to you again, we're not having a factual determination at these hearings. Your deliberations today are refined to, or restricted to whether you're going to affirm the decision and or remand the decision for further proceedings. If there is some sort of factual determination to be made, the commission is not empowered to make factual determinations. We aren't going to necessarily do that. We're not going to hold a testimony on evidence of value for 2022. So your decision today would simply carry forward the administrative law judge's decision through 2022 without any consideration of a new value for that year. The parties have previously stated that they're not contending there's factual basis for not amending that subsequent year. They just want to make sure that that subsequent year will have a factual determination and a finding of value that's different than the prior years for this case, if that all makes sense. With that said, you got any other further questions? And then we'll hand it back into deliberations. Again, the only question, it's a lot of me talking, ultimately just saying we have to decide, is your decision going to carry forward through tax year 2022? Or do you think TAC 2022 needs a separate factual determination?
I don't know that they're gonna get any additional data, what they presented.
So that's the question I need you to answer. If you think they need additional data in 2022.
I don't know, chief. They know their county better than I do.
But as we previously said, excuse me, I guess correct me if I'm wrong, the contention was not from the county that they are otherwise seeking to present additional data for 2022, but rather they just wanted to affirm that any value carried forward would be values previously decided by the judge and or the whole proceeding would otherwise be remanded.
Yeah. Quite complicated, isn't it? Doesn't matter to me.
So,
It's not, it's the county.
all right, so I just need a motion and a second for me that this appeal will now include 2022.
Do we have a motion and a second to include tax year 2022 with the tax year appeals of 2020 and 2021?
So,
All in favor?
Aye.
All opposed? The ayes have it with all. So to summarize again, we're not hearing any testimony or evidence as to tax year 2022. The commission's decision today will either carry forward the value as determined by the administrative law judge through that tax year. Or otherwise, if the appeal is remanded back for further consideration, that appeal will also include 2022. And at that time, you can introduce additional evidence on that value year. Yes, all right, with that, we'll take a quick, we'll just do, is it like 5 minutes? Quick, okay, we'll take a quick 5-minute break. We'll come back here. I'm trying to figure out my time. I have 11:12 on the clock. Well, how about we just come back at 11:20? All right, we'll go ahead and get started here. To summarize where we were at, we heard the taxpayer's initial argument about why he believes the initial decision of an order of the administrative law judge should otherwise be reversed and remanded for further proceedings. Press the tax year 2022 issue. I'll now hand it over to Montgomery County. I guess to your arguments as to why you believe the administrative law judge is correct and or you can also, but I'll leave that to you.
Montgomery County does not believe that Judge Cochran made an adjust it properly. Even with the additional explanation Mr. Catnamy said, he failed to explain the adjustments or the lack of adjustments for such improvement types and square footage. For example, at Montgomery County hearing, King's Privilege was a nightclub and Golden Corral is a cafeteria style restaurant. Neither of these being a full-service restaurant such as the subject property. The nightclub was built with a ridge frame and metal skin and is more in line with a warehouse-style full-service restaurant. As for square footage, the fact that most properties are leased out on a basis would lend to the belief that buildings with thousands of square feet or less than the subject property have to be adjusted to account for the differences in the building's ability to generate income based on size. Mr. Catnani showed no evidence to support that an adjustment was not warranted during the initial hearing. As per E.B. Kessel Jr. versus Shelby County, proper adjustments must be made for sales comparison to be aware of the value of the subject property. Mr. Catnani did explain in his appeal to the Assessment Appeals Commission a furthering argument about land values, but his argument is based on the values placed on the assessor's property record card for the 2019 review. The assessor's property record card attributed values to such line items as land or improvement are not reliable indicators of such values taken by themselves due to the nature of mass reappraisal. The appraisal value as a whole is more indicative of fair market value rather than the sum of its parts. Arguments based on pieces of the whole values have already been addressed in such rulings as Foxworth versus Polk County and Ray versus Knox County. As per Foxworth versus Polk County, the problem with evaluating a property tax assessment on the basis of pieces of the record are at least twofold. First, the pieces may not be comparable to each other, i.e. the value attributed by the CAS system to a typical component may not represent the true contribution of the component as represented in the subject property. Second, the pieces are a part of the whole that is merely a computer-generated approximation of a legal standard of fair market value. And as per Ray versus Knox County, is the value of the property as a whole which must be determined rather than one. Mr. Catnani's argument against the reasoning of no adjustments needed for location are invalid due to the fact that they are based on the assessor's land values given to the property record card and not due to his own determination of land value for each comparable property. Montgomery County does agree with Mr. Catnani that E.B. Kessel Jr. versus Shelby County only states that you must adjust for the comparable sale, not how you must adjust for sales. Although Montgomery County would like to make the point that just as you must be able to back up your reasoning for making an adjustment with quantifiable data, you must also back up your reasoning for not making it. Mr. Catnani failed to provide quantifiable data to back up his reasonings for adjustments he did. Montgomery County does not believe that Judge Cochran made an error in his findings that estimated leases and not provable. The passage that Mr. Catnani provided from the 11th edition of the Appraisal of Real Estate, there is no mention of estimated rents being indicative of market value. Montgomery County does agree with the fact that signed leases, proposed leases, and asking rents are good indicators. These are what makes up the fee simple market rent. Leased rent is market rent. Looking for market rent in this case, which would be fee. There is no evidence produced from Mr. Catnani at the hearing or in his appeal to the assessment appeal that these estimated rents were in fact based on actual rents or asking rents. Mr. Catnani used the CoStar triple net market rent value produced by CoStar using estimated rents. As per CoStar, the definition of estimated rent is the estimated amount the tenant pays in rent per square foot per year or month based on the asking rents of building at the time the tenant moved into the current building. As stated at the administrative hearing, most of those restaurants within the subject market area were built for the current owner no later than 2016, with most tenants and or owners having occupied their building for decades. If the estimated rent is based on the rent at the time, then some of these estimates are decades old. Additionally, on CoStar to back up what market rents are being night rents. Was the rents from all surrounding building types, rents for similar buildings as a subject? Are they even in the same location or city as a subject? There's no evidence to support that these estimated rent values are in actuality market value as Mr. Catnani needs. Provable leases are the foundation to the income approach in which the appraiser is to analyze and produce a market rent for the subject property for valuation. This would be the same as comparable sales being used as the foundation for the sales comparison approach. An appraiser would not use the estimated home values on Redfin as comparable values to produce the credible valuation of subject property of a home. At the hearing, Montgomery County produced evidence and testimony why we felt the estimated rent was reliable. Mr. Catnany had the opportunity at the hearing to cross-examine Montgomery County and did so in this, and Judge Cochran. Mr. Catnany also failed to provide supporting evidence that the enclosed porch would rent. This is one of the main things he talked about in his income approach, as he was talking about how the area of rent would be less than half of the rest of the restaurant. And Montgomery County asked Mr. Catnany during the administrative hearing, and response at approximately 18 minutes and 40 seconds on the hearing record was this, that it drops his rate down. There was no valuation to show that this area would rent for half the amount as the rest of the restaurant would. There is no justification to show that the enclosed portion of the building would lease or sell at a different rate per square foot than the rest of the building. Montgomery County believes that that is why a big part of the reason why Judge Cochran unreliable data. In regards to Mr. Catnany's request for COVID relief, Montgomery County addressed this issue at the administrative hearing. There had been no substantial proof within the subject's market area to warrant that an adjustment needed. In fact, property values continued to climb in Montgomery County during this time. We understand and acknowledge that the fact that the business entity portion of Tiltal suffered during COVID, but the value on the property record card is only for the real estate portion of the subject. Of all the articles produced by Mr. Catnany, none are specific to the subject's market area. Davidson County is not Montgomery County, and the rules and regulations that affected many businesses during that time were not the same between the. Montgomery County has many questions about how the external obsolescence was figured out by Mr. Catnany, but feels that this hearing is not the time or place for it. So issues should have been addressed during the initial hearing, or we should have responded to the late filing with those questions. If this commission does find that Judge Cochran failed in his duty to render a proper decision on the COVID issue, then Montgomery County would like to point out the fact that both Mr. Catnany's external obsolescence used values that were unsupported by Mr. Catnany in his direct. But both of these approaches having ruled unreliable by Judge Cochran, the workup done by Mr. Catnany would have also in turn produced an unreliable for COVID obsolescence for Judge Cochran to apply. The initial decision in order affirmed the value adopted by the Montgomery County CEO in 2020 and carried forward that value in 2021. There was no new value produced by either side for 2021, and therefore no value in which Judge Cochran could apply external obsolescence.
Any questions for Montgomery County at this time from our commission? Right, hearing and seeing none, Mr. Catnany, I'll let you have a brief time for any reply argument.
I have nothing further, Your Honor.
Right, with that, we will enter deliberations. I will just again reiterate the charge of the commission as this is my role as executive secretary sitting with ALJ with the commission today. So again, we're under that same standard, 67-5-1506, I believe, that states the commission may affirm the decision of the administrative law judge. You may remand these proceedings for further consideration. You can reverse the decision for one of those bases set forth by law. Generally speaking, it's going to be, did you find that the administrative law judge misapplied the law, or did they otherwise apply the law correctly or incorrectly? Was the administrative law judge's decision supported by evidence that is both substantial in light of the entire record, meaning does the record support the decisions made by the administrative law judge, including the hearing recording? And then otherwise, as long as you find there was no, the decision was not arbitrary or not based upon an abusive procedure, one of those other factors that's set forth in the statute. So again, generally speaking, did you believe the administrative law judge is correct and supported by evidence or not? And what, we'll go from there. So with that, I will again hand it over to our presiding member, Mr. Turner, for deliberations. Any thoughts on this appeal?
Hearing no further questions or comments, do I have a motion to uphold the administrative law judge's findings and a second?
Yeah, God make a motion.
We have a motion to uphold the administrative law judge's findings. Do we have a second? A second.
Right, so the motion is to affirm the administrative law judge's decision. Like I said previously, that affirmation of value, that value being as noted on page 6 of the order for a total value of $2,342,600 as affirmed, would otherwise carry forward for tax years 2020, 21, and 2022. All those in favor of the motion?
Aye.
All those opposed? The ayes have it, with all commission members voting aye. That concludes our business, our final appeal for the day, and all the businesses for the Assessment Appeals Commission. The proceedings are adjourned. We'll discontinue the recording and meeting here in just a moment. Does that all make, I just want to confirm that that matches your understanding and expectations for the 2022 year. Okay. Then that, we're all concluded. Thank you, Mr. Catanani. You're welcome to disconnect. We'll next time, commission members, so reconvene tomorrow. Not all of you, I know Mr. Bowles will be joining us here. Mr. Brian Eads will be joining us for the commission. We'll be again at 9. We have one appeal, should be relatively short.
Then you just prepare the paperwork and email it to me.
Okay. Yeah, we send you a copy.